The time belongs to the gentleman from Texas.
And a little flexibility on the time. I appreciate the chairman. Madam Attorney General, am I correct that under your leadership, the Department of Justice has prosecuted cases of non-citizen voting? So it's false, as some of my Democratic colleagues have claimed, that it doesn't happen.
Yes.
I ask that today because we're voting on the Save America Act today to enact common sense policies to ensure only American citizens vote in American elections and enact federal voter ID laws. But it's true, for example, that in just this month, a federal grand jury in Newark indicted 2 men with illegally voting in federal election and making false statements. Mohammed Mazammel and Mohammed Shakil were non-citizens at the time they registered to vote. This happens, it happens regularly, and you're prosecuting those crimes, correct?
Yes.
But does that prosecution of those criminals overturn their previously cast votes?
That's all pending.
But it does not overturn votes that they've cast, right? So passing the Save
no,
America Act would help deal with that problem.
Yes, Congressman.
Second question. As Attorney General, you're in charge of the Executive Office of Immigration Review, correct?
Yes, Congressman.
The Biden-Mayorkas regime caused the immigration court case backlog to explode, correct?
Explode.
Does that sound about right, that in September of 2020, 4 months before President Biden took office, there was a backlog of 1.5 million cases, but by the time President Biden left office, the backlog reached nearly 4.2 million cases?
It sounds about right, but I don't have the exact numbers.
It would be accurate to say that most individuals who file for asylum have a meritless or fraudulent claim?
Most. I don't have the numbers.
Oh, so does it sound correct that of the asylum cases adjudicated in FY 2023 under the Biden regime, that only 14% resulted in an asylum grant and only 12% in fiscal year 2024? Does that sound correct?
It sounds correct. I'm sorry, I don't have the numbers.
Could you get that information to us to verify that data?
I'll get all that information to you.
Under the Trump administration, immigration judges complete an average of 65,000 cases per month, the highest average completion rate in at least a decade. Does that sound correct?
That sounds correct.
Ms. Bondi, how many new cases under EOIR received in fiscal year 2025 have you all had? And of those, what percentage have been granted asylum? Do you know?
I can try to get you those numbers. I thought I had those.
That'd be great, because my question is whether President Trump's decision to pause asylum in the wake of the shooting of a National Guardsman by an Afghani here in Washington, D.C., in the nation's capital, helped to stop the backlog in your office. Does that sound correct?
Yes, Congressman.
My point being that the leadership of this administration is ending the backlog, reducing the backlog, making sure that we don't have fraudulent asylum claims clogging it, and keeping Americans safe. Is that correct?
Yes, Congressman.
So a couple other quick questions on another important topic that has been raised by colleagues on both sides of the aisle with respect to the Epstein case. A few questions. One, Jeffrey Epstein was charged in July 2019 for sex trafficking under the Trump administration in his first term. Is that correct?
Yes, Congressman.
And that Ghislaine Maxwell was charged in 2020 also under the Trump administration, correct?
Yes, Congressman.
So it is safe to say that the administration led on that issue and that there was silence in the previous administration. Is that correct?
Yes, Congressman. Almost complete silence from everyone who's been trying to still talk about Epstein. They didn't say a word under the Biden administration. Nothing.
And I want to make one other point and then another question, though, that is important. I want to make one observation, and that is that we've heard the information today, which is troubling, that Jane Doe's, that victims' information was made public and was unredacted in the files that were released on Friday. So my question is, some of us had argued when we were dealing with the discharge petition in Congress, that when Congress inserted itself into the process, that we needed to be very careful to ensure that we were protecting victims. So a question that is both, I just want to make that clear, that some of us were fighting for that here, and we didn't get a chance to amend it or change it. So that was concerning. But a question a little more pointed, I have to say, is why, though, were the victims' names released that shouldn't have been? That there were names in the files, that these Jane Does, that their names shouldn't have been made public, when there were some accusers whose names were redacted? That's question one. Mm-hmm. And question two was that Ghislaine Maxwell was put in jail for trafficking minors. Rightly so, and you properly said here at this table, you hope she dies in jail. Well, I want to know, will anyone besides her or Epstein, which I congratulate President Trump's previous administration and this Department of Justice for continuing all of that, but that they were indicted, but will anyone else be indicted and prosecuted under this, given the information that's in front of us? So 2 questions.
Thank you for letting me answer that. They didn't want to hear my answer on the other side. Yes, given the tight time frame of 30 days, I believe we got everything released within a little over 60 days. I'm talking as fast as I can. My time is up. We did the best we could immediately. If everyone's been coming to view the documents, if someone's name should not have been redacted. We're releasing it. If someone's name was redacted, we said right away, was not redacted and should have been, meaning a victim. We went back and redacted it. We're doing everything we can based on the tight time frame and over 3 million pages that we released that Donald Trump signed for pure transparency. Second, what was your second question?
About whether another individual will be indicted.
Absolutely.
And
Thank you for asking that. And they never wanted to hear the answer to that. We have pending investigations in our office.
The hearing had already covered non-citizen voting cases and the immigration court backlog that ballooned under the previous administration. Roy shifted gears without warning. He reminded Bondi that Jeffrey Epstein faced sex trafficking charges in July 2019 under the first Trump term. Ghislaine Maxwell faced her own charges in 2020, still under that same administration. Bondi confirmed both facts. Roy then drove home the contrast. There was near total silence from the people now loudest about Epstein during the years that followed. Bondi agreed. The point landed hard. The original cases moved forward when one team held power. The files themselves only poured out after a new law forced the issue. That law was the Epstein Files Transparency Act. President Trump signed it on November 19, 2025. Congress had pushed the measure with near unanimous votes. The Department of Justice then began releasing material. An early batch arrived in December. The larger drop came around January 30th, 2026, adding more than 3 million pages along with thousands of videos and images. Officials described the total production as nearly 3.5 million pages drawn from Florida and New York cases, FBI files, Inspector General reviews, and other sources. The stated goal was pure transparency. What arrived instead was a storm. Victim names and identifiers appeared unredacted in places they never should have. Attorneys for survivors reported dozens of people whose full names or personal details sat in plain view, including individuals who were minors at the time of the abuse. Some documents listed multiple names with almost no blackouts. Home addresses, email fragments, and other markers showed up in searchable text. Victims and their lawyers expressed anger and fear. One attorney called the failures thousands of mistakes after the department had received a list of hundreds of names meant to guide redactions. The department later admitted redaction errors. Teams went back through the material and applied additional blackouts. Bondi told the committee her office moved as fast as possible under a tight deadline. She said if a name should not have been public, they corrected it. The damage was already done for many who felt exposed all over again. Roy pressed on the double standard. Some accusers saw their names protected while others did not. Bondi pointed to the volume of pages and the speed required. She insisted the department acted in good faith and fixed what it could. The exchange left the clear impression that the process had been messy. Later, closed-door questioning of Bondi produced more friction. She directed many operational questions toward then Deputy Attorney General Todd Blanche. She declined to discuss certain conversations involving the White House. By early April 2026, she was out of the job. The official line described a transition. Reports and reactions tied the move at least partly to the handling of the files and the political heat that followed. Throughout the public debate, one question kept returning. Did the millions of pages contain evidence that could support new charges against others? Bondi told Roy the answer was yes in the sense that investigations remained pending. Other voices inside the department sounded more cautious. Blanche had indicated earlier that a review found nothing sufficient to prosecute additional people beyond what was already known. The gap between those statements fueled speculation. Online discussions and commentary pointed to names that appeared in flight logs, emails, or photographs. Some of those names belonged to powerful figures from business, politics, and entertainment. None of those appearances by themselves proved criminal conduct. The files included material that officials later noted contained untrue claims about certain individuals. Careful reading remained essential. What the documents did confirm was the scale of Epstein's network and the long timeline of allegations. They showed associations, travel, and communications that stretched across years. They also showed how earlier non-prosecution arrangements in Florida had limited the reach of justice for many victims. Maxwell's conviction stood as the major courtroom outcome after Epstein himself was found dead in his cell in 2019 under circumstances that still generate questions. Official reports described the death as self-inflicted. Alternative theories never fully faded. The new releases added volume, but did not close every open thread. Roy's line of questioning also touched the practical reality of victim protection. Lawmakers from both parties had warned during debate on the transparency bill that names of survivors needed careful handling. Some argued Congress should have built stronger safeguards into the statute. Once the files were out, the mistakes became public. Victims described feeling re-traumatized. Advocacy groups called for better processes if any future releases occurred. The department said it had worked to correct the record and would continue to protect identities going forward. Trust remained fragile. The pending investigations Bondi referenced offered the only concrete forward path mentioned in the hearing. No major new federal indictments of additional co-conspirators had been announced by the middle of 2026. Separate matters moved overseas. A former Norwegian official faced charges in his own country. Other international figures drew scrutiny. Inside the United States, the public conversation stayed fixed on whether the American system would produce more accountability. Survivors and their representatives continued to press for full unredacted access where the law allowed and for genuine follow-through on any viable leads. The political temperature around the case never cooled. Democrats on the committee accused the department of selective redaction that protected the powerful while exposing the vulnerable. Republicans pointed to the original charges under the first Trump administration and to the new law that forced the files into daylight. Bondi's absolutely became a talking point on one side and a target on the other. Later testimony showed her emphasizing that the department had released the material under a presidential directive for transparency and that any remaining issues were being addressed. The back and forth kept the story alive long after the hearing cameras turned off. What the files ultimately revealed was both more and less than many expected. They confirmed long-known connections and added granular detail. They also left large stretches of black ink and unanswered questions about who else might have enabled or participated in the trafficking operation. Speculation filled the gaps. Commentators and online voices offered theories ranging from deliberate cover-ups to simple bureaucratic failure. None of those theories substituted for evidence that could survive a courtroom. The department's earlier public position that the files did not support broad, new prosecutions sat alongside Bondi's hearing comments about pending work. The tension between those messages kept interest high. Roy used his time to connect the Epstein discussion to larger themes of accountability. He noted that the same department prosecuting non-citizen voting cases and working to shrink immigration backlogs was also the one holding the Epstein material. The implication was that leadership mattered. Bondi agreed that the current administration was moving to reduce fraudulent claims and keep Americans safe. On Epstein, she returned to the pending investigations. The exchange closed with the chairman cutting time, but the substance lingered. Viewers and readers walked away with a clear sense that the case was not finished. Months after the hearing, the pressure continued. New legislation appeared aimed at giving state attorneys general, survivors, and members of Congress stronger tools to force additional compliance. Inspector General reviews examined whether the department had fully met its obligations under the transparency law. Victims' lawyers kept filing motions and public statements. The core demand remained consistent. Release everything the law requires. Protect the people who were harmed. Pursue every credible lead without regard to status or connections. The story of the Epstein files is ultimately a story about power meeting process. One administration brought the original charges. Another signed the law that opened the archives. The resulting documents exposed both the breadth of the network and the limits of institutional capacity. Redaction failures damaged trust. Conflicting signals about future prosecutions left the public uncertain. Bondi's direct answer to Roy's question provided a moment of clarity that later events complicated. Whether those pending investigations produce further indictments remains the open question that still drives the conversation. For the survivors, the files represent both validation and risk. Their experiences were documented in government records. Some of those records then exposed them again through avoidable errors. The official corrections came after the fact. The deeper demand is for a system that prioritizes their safety while still delivering answers. That balance has proven difficult to strike. The hearing showed lawmakers and the Attorney General wrestling with exactly that tension in real time. As more eyes examine the released material, new details continue to surface. Flight records, email chains, and photographs invite fresh scrutiny. Each new discovery renews the call for accountability. At the same time, responsible discussion requires separating documented facts from rumor. Names appearing in files do not equal criminal liability. Allegations require